Hello viewers, we had started the session at 3:30 as promised. This AMA session was to continue, but I have seen that due to certain technical issues, we have not been able to continue with the session. But notwithstanding the same, that technical hitch has been recovered now, and we are here back with you. I again welcome you on behalf of NRI Legal Services. And in today's session, as I told you earlier also, we'll be discussing regarding the property disputes of NRIs which they are facing in India. There are large number of property disputes which come to our notice, and during this session of Ask Me Anything, I will be assisted by Advocate Ashna, as I told you earlier also. Ashna, you can introduce yourself.
Hi everyone again. I'm Advocate Ashna Singh, working as a legal associate in NRI Legal Services.
Okay. I hope that there should not be any technical issue now.
I hope
And
so,
we'll
sir.
continue with the session. And we were discussing about the property disputes of NRIs. Property disputes we have seen arise regarding to ownership of the property, title of the property. There can be property disputes regarding inheritance on the basis of law succession, on the basis of the will. Also the property disputes arise amongst the NRIs. And also we have seen that there are property disputes pertaining to builder and buyers. Builder has not handed over the possession of the property to the buyers in time, and it results in a dispute. What the buyer can do, we'll discuss those issues. We'll also guide you how to resolve these issues, these property disputes. It is also seen that there can be disputes amongst the tenants and the landlord, and tenant is not complying with the various terms of the agreement. Then the property dispute arises amongst them, and when such type of dispute arises, then how to resolve, we'll discuss that also during course of the session. And also there can be property disputes pertaining to joint possession of the property, where the property is being owned by many owners. Then how to resolve that property dispute. Also we have seen that there are property disputes on issues like landlord and buyer and seller. The property has been decided to be sold, and the buyer is there to accept the sale of the property, but agreement to sell, even after agreement to sell having been finalized, the seller is not implementing the agreement to sell, is not going for the registration of the sale date. Then the dispute arises amongst them. So there's so many various kinds of dispute pertaining to properties which you can think of, which we face in India, and these are really faced by NRIs, and we are always there to assist the NRIs to overcome these property disputes. And it is advisable that since the property disputes are very tricky, they are complicated in nature, it is always better that whenever such issues come, you must hire a law firm or a property advocate who can assist you in getting over those issues. Have you received any question?
So we have received 4 questions earlier. Should we repeat it once?
Yeah, we can guide them because the session had to be interrupted in between because of technical issues.
Right, sir. Right.
You can tell me the questions, then we will handle those questions.
Okay, sir. So one question was from Mr. Malkeet Singh. His question was, I have a flat in Mohali. I want to give this property on rent. Can I give this property on rent through power of attorney holder?
Okay, Mr. Malkeet, thanks for your question, and I would like to guide you here that the property can be given on rent through the power of attorney holder, as you have brought out. Power of attorney holder can be authorized by you properly, giving him the rights to give the property on rent. Even the NRIs give power of attorneys to their trusted people. That has to be ensured that the person who is indulging into any agreement on your behalf, he should be a trusted person. And moreover, the power of attorney, whenever given in a foreign country, it has to be duly apostilled, and whenever it comes in India, it has to be duly embossed, and only then it becomes a valid power of attorney. But so far as your property to be given on rent is concerned, even it can be given through a authority letter. That is possible, but it is always advisable to give it through a power of attorney, because subsequently if any dispute arises between the property owner and the tenant, that can be sorted in the court. Any other question we received?
Yes, sir. Another question. I don't remember the name of the person,
Okay.
but his question was: if a person has occupied a property without the consent of the owner of the property and is living on it from past 10 years, can he claim the plea of adverse possession?
Okay,
May
you
I, sir?
handle this.
Okay. We would like to clarify here that in order to claim the plea of adverse possession, the possession must be of at least minimum 12 years by the possessor, and the possession must be uninterrupted and it should be peaceful. That is, the owner must not be interfere with the possession of the possessor. Further, if as per the stated facts, if in the given situation the owner has already requested the trespasser to vacate the property time and again, then the trespasser cannot claim the plea of adverse possession. I hope this clarifies your query.
Okay.
Then, sir, there was one other question.
Okay. Any other question? Let
Yes,
me here
sir.
add on something
Yes, sir.
regarding the adverse possession you have brought out.
Yes, sir.
And this gentleman is asking whether the owner, the person who is illegally occupying the property, can claim adverse possession.
Yes, sir.
As you clearly brought out that minimum 12 years is required for
Yes.
claiming the adverse possession. And it is advisable to NRIs that if they they have properties in India, it may be agricultural land or it may be residential property or a commercial property, you should ensure that such a situation does not arise that is leading to adverse possession. Whenever you give the property, it should be duly given on rent, given under an agreement. Even if you are employing a caretaker, there should be a caretaker agreement also. So it has to be ensured that the person who is holding the property on your behalf does not hold the property peacefully. There has to be an interruption on your behalf so that he cannot claim the adverse possession at any stage.
Right, sir.
Okay.
So there was another question.
Hmm.
I have a query regarding my flat in Gurgaon. When I went to take over the possession of my flat from the builder, it was observed that the flat is not as per the specifications mentioned to me at the time of sale by the builder. He is forcing me to take over the possession and threatening that I will have to pay the penalty if I fail to take over the possession. What can I do?
Okay. Ilman, the builder, even if he is threatening to you that he will impose penalty, you should not bother about that, because he has failed in handing over the possession of the flat to you as per the specifications, which means that he has violated the terms of the buyer builder agreement. And if he has violated the terms of the buyer builder agreement, then in that case you can make a claim against him. You can approach the consumer court, and not only the claim the money which you have paid to him, but you can also seek compensation. Even you can seek the interest from the builder.
Right.
That's right.
Yes,
Any
sir.
other question?
Yes, sir. One fourth question was: I am a resident of Germany. My friend's father has left a will bequeathing his entire property to one of his relatives. Can my friend claim the property of his father? May I, sir?
Yeah, please.
Okay. So it is clarified that the will can be challenged in the court of law, that it is not executed properly on the grounds that there are no witnesses to the will, or there is some sort of overwriting in the will, or that the signatures on the will are forged and fabricated. If your friend is able to prove that the will is not genuine, then he can claim the right over the property, and by way of natural succession, being the only legal heir of his father. I hope this clarifies our question.
Right, Ashna. And moreover, if the will has been executed genuinely and
Right,
it is duly registered and it can be proved through witnesses, then the gentleman may not be able to claim the property, because
Yes,
the will is genuine. Any other question?
Hanji sir, there is a question from Mr. Rahul Thakur. I have purchased a flat from builder in a society in Bangalore, which is still under construction as per the builder buyer agreement. I have paid the entire money to the builder. He was required to hand over the possession to me in June 2021. He has not given the possession till date as the property is still under construction. What should I do?
Um,
Rahul sir, Rahul Thakur.
Hello Rahul, thanks for your question. Let me clarify to you here that the builder has failed to hand over you the possession of the property as committed by him, which was to be given in June 2021, right?
Right, sir. Right.
Now, since the property is not being handed over to you as per the terms of the agreement, you can always approach a court of law. First of all, you may like to give the legal notice to the builder, and if he does not comply with the legal notice, then you can approach a court of law, that is, you can go to the consumer court. Moreover, I must clarify that when you approach the consumer court, you can claim the compensation, as I told you earlier also, and also you can claim the interest part on that money. And moreover, if the property is registered with RERA, then instead of approaching the consumer court, it is advisable that you approach RERA. What is RERA? RERA is a real estate regulatory authority. Real estate regulatory authority has been come into force since 2016, and most of the projects by the builder are registered with RERA, and thus you can get the speedy justice in before the RERA authorities. So that is what I advise you, that in case the property is registered with RERA, you must approach the RERA authorities. Okay, I hope it is clear. Any other question?
Yes, sir. Miss Navpreet Kaur is writing, I have been living in London from last 15 years and my younger brother has been taking care of my self-owned agriculture land situated in Rudka Kala in Punjab. Before coming to London, I requested him to take care of it, and till today I am paying for maintenance of the land. Few months back, I visited Punjab to see my land. My brother blatantly refused to hand over the vacant possession of the land, and I saw that he is cultivating his own wheat over it. Can I get my land back? May I, sir?
Yeah, please.
Okay, so Miss Navpreet, in such a situation, as you have given the property to your brother, yes, to your brother in the capacity of a caretaker, so he cannot claim to be the owner of the property, and the property is completely yours. You are the owner of the property. So for this, you can of course file a suit in the appropriate court of law, and you can claim back your property. Yes. I hope this question is clear.
Okay, thanks for this answer. Any other question, Ashna?
Yes, sir.
Okay.
I'm a resident of UK. My grandfather has an agriculture property in Sanewal, Ludhiana. After his death, my father's brother is not giving share of the property to my father. My father and uncle are the only legal heirs of my grandfather, who expired without making any will. My uncle is in possession of the property. How this dispute can be resolved? This question is from Sir Roop Barad.
Okay, Mr. Rubra, thanks for your question. Let me clarify to you that as per the laws of succession, as you stated that the property belongs to your grandfather,
Yes, sir.
and there are only two legal heirs, that is your father and the uncle, to that property, and presently your uncle is in possession of the property. Your father being one of the legal heirs, he has equal share in the property, whether it was self-acquired property of your father or ancestral property of your father, because in this case there are only two legal heirs, that is your father and the uncle. So he can ask your uncle to hand him over his 50% share of the property, but if the uncle does not comply and does not adhere to his request, then he can always approach a court of law and seek his 50% share in the property from the court of law. Right?
Right, sir.
Okay. Any other question?
No,
Ashna?
sir, not yet, sir. Not yet.
Okay. We were talking about the property disputes of NRIs in India. We have seen that also we discussed few of them here during the question answer session, that the landlord tenant dispute are very, very common in India. The NRIs are owning property in India, and they want to safely secure those properties, and sometimes they want also some income from those properties, so they generally give the properties on rent.
Right.
So when you're giving property on rent, you must ensure that there is a proper rent agreement between you and the tenant. As also earlier brought out, that even rent agreement can be through the power of attorney, who is your interested person. And what kind of dispute arise amongst between this landlord and the tenant? Sometimes the tenant refuses to vacate the property,
Right.
even after expiry of the terms of the agreement. Even the tenant can refuse to hand over the vacant possession. Tenant can also violate the terms and conditions of the contract by subletting the property, or by not adhering to the terms and conditions, like pets are not allowed but he keeps the pets in the property. So there can be various reasons for dispute among between the landlord and the tenant. So to overcome these disputes, as I said, the rent agreement should be very clear. It should have very clear instructions in the agreement, that if any of the party violates the terms and conditions, then how the property can be vacated. And moreover, it should be initially amicably settled down, because if you don't amicably resolve this issue, the courts are going to take a lot of time to resolve those issues, and then subsequently you can go to the court if it is not amicably resolved. So that is how you can overcome the landlord tenant disputes.
Right, sir.
Any other question?
Hanji sir, there is one question from Mr. Sunil Kumar. My friend's father expired in the year 2020 without making any will. His younger sister is claiming for an equal share in the property. Can she get an equal right? May I, sir?
Yeah, please.
Okay, so Mr. Sunil Kumar, in such a situation, as per the Hindu Succession Act 1956, both sons and daughters are equally entitled over the self-acquired property of the father. So definitely your friend and her sister are equally entitled to the share in the property in equal shares. I hope this clarifies your query.
Yeah, it is clear. So they are equally entitled to share the property with 50% share each.
Yes, sir.
And even for the ancestral property, there are guidelines that the act has been, Hindu Succession Act has been amended in 2005. Now even in the ancestral property, the daughters have been given the equal share along with the sons. They are also termed as the co-partner of the property. That is just for your guidance. Any other question?
Yes, sir. There is one question from Mr. Arpit Sethi. Is there any way to reopen a partition done in the year 1998 so that the daughters can get the right over father's ancestral property? Yes, sir.
Yeah, please.
Okay, so Mr. Arpit, once the partition has been duly executed and the shares are distributed as per the prevailing law of 1998, the partition cannot be reopened. So the daughters cannot claim their right over the property now at present. So yes, once the partition is done, it cannot be reopened.
Oh.
So, yes.
Just I would like to clarify one thing here, that why she cannot claim, because earlier it was ancestral property, but as soon as the partition takes place of the property, it loses its ancestral nature. So it not being ancestral property anymore after the partition. So she cannot claim share in the property.
Right, sir, right. So there's one another question from Mannat Khanna. My friend's father has a property in Chandigarh. He expired in the year 2021 and thereafter the property was transferred in the name of the mother, my friend and his sister. Now my friend and his sister wants to transfer their share in the name of their mother. How can they do it?
Okay.
Mannat Khan, sir.
Mannat
Khan.
Hello Mannat, thanks for the question. Let me clarify, as it is evident from the question, that the property needs to be transferred in the name of your friend's mother, son and the daughter. So what is the procedure for it? First of all, once the father had expired, and these three being the legal heirs, they have the equal right, equal share in the property, and they have to approach the concerned revenue authorities, put up an application, and then by complying with the various instructions of the revenue authorities, they have to they can get the property transferred in their name, they being the only legal heirs. Only thing is that they have to go with all the documents, like ownership documents in the name of father. There should be properly tax receipts that all the taxes have been paid pertaining the property. They should have the identification proofs.
Right.
Then there may be requirement of the witnesses who will testify, and there may be other basic requirements which have to be followed as per the concerned state procedures of the revenue authorities. and thereafter the property can be easily transferred in their names. Right.
Hanji sir, there's another question from Miss Heer Bajwa. She writes, my father owns a flat in Bandra, Mumbai. It is his self-acquired property. I have one sister who is married. She is pressurizing our father to give her 50% share in the property. Is it legal?
No. Let me clarify here that she cannot pressurize her father to give her 50% share, because it is the self-acquired property of the father. It is the wish of the father to whomsoever he may like to give the property. Till the time the father is alive, the property belongs to him. He is the owner of the property. It is his self-acquired property. Neither the son nor the daughter or any other person on earth can force him to give the share to him. The only thing is that subsequently, if the father expires without making any will, if he is like he is expired intestate, in other words, then in that case your sister will be entitled to equal share in the property. Otherwise she cannot force the father to give the 50% share in the property.
In the property, correct.
Right.
Right.
I
No
hope it
other
is clear.
question yet, sir.
Okay, any other question?
No, sir. Not
No
yet.
question?
No.
Okay. Let me also clarify that as we have said that there are disputes about the builder and buyers. When the builder buyer dispute, how it has to be avoided? First of all, you have to say that there is a proper builder buyer agreement, and the terms and conditions which are specified in the builder buyer agreement are very clear to the buyer as well as the builder. And also the buyer should also keep a clear record of all the payments made to the builder, and it may be either through checks or maybe through bank transactions, NEFT or so on. And also it has to be ensured by the buyer that the builder has to hand over the property in time, and if the builder has failed, as also discussed during the session, then the buyer can take him to the court of law and claim the compensation and the interest for the money he has paid to the builder. Also we have seen that there are disputes pertaining to joint properties. Joint property disputes means they are co-owners of the property. The co-owners, when the property is jointly owned, then the other co-owners are bound by the other co-owners. Then how to get this property separated? How we can get this property divided? The only way to get it divided is by way of partition. It can be by way of partition deed amongst all the co-owners, which can be presented subsequently to the authorities, and the property can be demarcated and partitioned, wherein all the co-owners can get their own share in the property. Or there is another way of getting it partitioned, that is by approaching court of law. The court of law, in case of say for example in Punjab, the co-owners, specifically I will go to the NRIs. If NRI has to claim his share in the agriculture land, then there is a special code which has been made in the revenue with the revenue authorities, that is the court of DRO, that is district revenue officer. That application can be filed for partition before the DRO, and then agriculture property can be divided on the orders of DRO after completing the entire procedure which has to be followed. Even the property which is residential property can also be divided through the court of law. It can be partitioned, but it has to be through the civil court.
So we have another question from Mannat Kaur. I am an NRI. I gave my independent house on a rent to a tenant after entering into a proper rent agreement. The tenant is not vacating the property even after expiry of the rent agreement. What should I do? May I, sir?
Okay, please.
Okay, so Ms. Mannat, in the current situation, you always have the option to go to approach the court and also to file an appropriate suit against the tenant so that the eviction can be done with the due process of law. Alternatively, you can also send a legal notice first to the tenant so that amicably the tenant vacates the property so that no litigation is involved. I think this would answer your query.
Yeah, that's right. Any other question, Ashna?
Yes, sir. There's another question from Mayank. He writes, I have a property in Ahmedabad, Gujarat. One of my relatives has requested me to give this property on rent to him without entering into any rent agreement and has assured me that he will keep paying the rent to me as decided. Should I proceed with his proposal or is it mandatory to prepare a rent deed?
Okay. Thank you, Mr. Mayank. You want to handle or should I handle?
As you say, sir.
Okay, let me answer.
Yes, sir.
Okay, Mr. Mayank, thank you so much for the question. Let me clarify to you that when any person is asking you to give the property on rent without entering into proper agreement, it means he has malified intentions behind it. Means the intentions are not good and he is likely to grab your property, take over the illegal possession, and to overcome that, it is always advisable that you enter into a proper rent agreement with him, and because that rent agreement can also be registered, and subsequently if that person is not vacating the property, you can easily approach the court of law and get the property vacated through the process of the law. So it is advisable that you should not give your property without entering into a rent agreement. He may be paying you the rent in cash or in otherwise, but it is always better that you enter into a rent agreement. Okay, Ashna, any other question?
Sir, I think this would be the last question from Mr. Honey Chawla. Hello, I have a property in Kolkata, West Bengal, and recently I got to know that a trespasser has entered on it and is not ready to vacate the property. Due to my business in New Zealand, I am unable to travel to India on regular basis, because of which I have authorized my sister to look after my property. Now I want to sell my property in Kolkata. By what way I can dispossess the trespasser? May I say?
Please.
Okay, so Mr. Honey Chawla, in such a situation, you always can file an appropriate suit in the court of law against the trespasser and get an order and a declaration from the court that he is an illegal occupant of the property, and you shall be declared the owner of the property. Once the same is done, you can always sell your property back in Kolkata whenever you come to India. I think this would just.
That's right, Ashna. Any other question?
No, sir. No.
Okay. So let me conclude here. Since there has been number of questions which we have answered, but during this session, have you got some questions?
Yes, sir. There's
before
one.
I conclude?
Yes, sir. Just one question.
Okay.
My father acquired ancestral property from his forefathers, which has not been partitioned till date. I have one brother and one sister. Can my father get this property partitioned and then transfer the share among us?
Yes. What's the name?
So it's lawmates. Some law
Okay,
firm.
it's a lawmates.
Yeah.
Let me clarify here that the property can be partitioned, as I just prior to this had explained, that if there is a joint ownership in the property or it's ancestral property, and in your case the property has come from the grandfather where the other children have inherited the property, and in case your father has to demarcate his share, then he can easily get it demarcated. It can be through the process of a partition deed, which can be amicably resolve the issue, or it can be by approaching the court of law. If it's since it's an agricultural property, then you will have to approach the revenue authorities in Punjab, but so far as other states are concerned, you have to approach the civil court for getting the property partitioned.
Right.
So that way, once the property is partitioned, then your father will become the sole owner of that property, and then he can transfer that property in your name,
amongst them. Yes, sir. Yes.
in the names of all the legal heirs
Legal heirs.
he has.
Yes, sir.
So that's all.
This is
Questions?
it.
Okay.
Yes.
Notwithstanding this, if in case we are receiving any more questions, we will come back to you individually, and we will be separately answering those questions if any more questions come subsequently. But only thing I want to advise that NRIs always face disputes pertaining to their properties, whether it is an ancestral property or it's a self-acquired property, or it's a property given on rent, or property has been purchased from the builder, or it's a joint ownership property. or it's a inherited property, maybe ancestral property. So there are a lot of disputes which arise pertaining to the properties of NRIs. In this session, we have tried our best. It had been our endeavor to resolve the queries which have been put to us, and in future also we'll be holding such sessions for you, and we'll be coming back to you with various topics. You are most welcome to clarify your doubts from us, and it is only advisable that since this property disputes are complicated in nature and tricky in nature, as I told earlier, so it is always better to approach a property lawyer or a law firm who can assist you in getting back your share in case there is some dispute pertaining to the properties. And if you have any query, you can send the queries to us, query@NRILegalServices.com. And at the end, we wish you all the very best. All the NRIs, greetings to all of you. Thank you so much, viewers.
Thank you.
And thank you, Ashna.
Thank you, sir.
Hanji.